afternoon.
Please, Your Lordship.
Yes.
In that matter, my name is Elias Mutuma. I do appear alongside my senior, Mr. Elisha Ongoya, who is appearing virtually.
For the petitioner.
For the petitioner, I have also Collins Mwenda, present in court. I have Edgar Busiega, present in court. Brida Kemati, appearing virtually. Robert Mutembei, appearing virtually.
Yes.
And my learned friend, Mr. Munene Kanata, present in court.
Present.
Thank you.
The petition applicant is also present in court for record purposes.
Okay. Respondent?
Your Lordship, if it be pleasing,
Yes.
in the matter I am Eugene Mukela. I appear alongside Masi Kanji, who should be joining us virtually.
Yes.
I don't know if she'll join. We appear for the respondent.
First interested party?
Good afternoon, my lord.
Good afternoon.
In the matter, my name is Eugene Lam.
Yes.
I appear alongside Ms. Ngata, Vice President.
Thank you. For the first interested party. Second IP? Yes.
I'll brief the news with Manas. So record for KUTHIKIRA is the community party.
Numbers for the second IP. Thank you. Third interested party?
May it please you, my lord.
Yes.
My name is Koti Ngata. I appear alongside my senior, Mr. Keleni,
Yes.
who will be joining us virtually. And Mr. Kebore here is present in court.
And Mr. Kithure, third interested party. I don't believe we joined anyone else. So may I begin by first extending my apologies. I'd given a time allocation of noon. I was not able to appear at noon. I was still winding up my virtual cause list. The ruling is ready. Let me just bring it up. So this is the ruling on the petitioner's notice of motion application dated 21st August 2024 and the respondent's notice of motion application dated 3rd September 2024. It's a 31-page ruling, so I will not read all of it. I set out the background to the matters from paragraph 1 till paragraph 12. I then covered the positions of the parties and the documents filed, just an explanation of what has been filed between paragraphs 13 all the way to paragraph 15. So I'll begin with paragraph 16, which is the first paragraph in issues for determination. Paragraph 16. The parties are in agreement on the issues for determination in this ruling, and they have largely cited the same authorities or authorities articulating the same or similar points of law in support of their relative positions and in opposition of the positions being taken by the parties on the opposite side of the matter. From the applications, the affidavits, and the written submissions, it emerges that the issues for determination are as follows. A. Whether the petitioner has demonstrated a prima facie case with a likelihood of success. B. Whether the respondent has approached the court with clean hands. C. Whether the petition would be rendered nugatory if the conservatory orders sought were denied and were not extended to cover the hearing and determination of the petition. D. Whether the respective applicants would suffer an irreversible and irreparable prejudice if their respective application did not succeed. E. Where does the public interest lie? And F. Costs. analysis on whether the petition discloses a prima facie case. The applicable legal standard for considering whether a prima facie case has been established in a constitutional petition is whether or not the petition in question raises arguable or triable issues of a nature that calls for a response or rebuttal from the party or parties on the opposite side of the dispute, and which arguable or triable issues have a likelihood of success. Put another way, the arguable or triable issues raised in the petition must be of a nature that, if the party or parties on the opposite side of the dispute failed to respond and rebut the position advanced in the petition in question would have a likelihood of succeeding. I must make clear from the outset that in determining the question of prima facie case at the interlocutory stage, the court must ensure that it does not delve into the relative merits or demerits of the contested legal and factual positions at issue in the petition. The role of the judge is to weigh those contested legal and factual positions to determine if, on the face of it, the petition raises issues canvassed at full hearing of the petition, rather than being dismissed at the preliminary stages, and the petition has a likelihood of success if the matter were to proceed to finality. It is clear that the petition herein raises arguable and triable issues that require hearing and determination post the interlocutory stage. This is not to say that those arguable and triable issues, such as questions of fair hearing, public participation, sub judice, and others, shall necessarily succeed. But they are most certainly of a nature and weight that make them fit and proper for full hearing and determination. This is not to say that the court has, at this stage, formed an opinion on the counter-arguments by the respondent, and to a lesser extent by the third interested party. That the petition is essentially incapable of determination in favor of the petitioner for the reason that the position of governor is a public office position with respect to which there can be no private need or expectation to hold office, a position adopted by the Supreme Court of Kenya in the case of County Assemblies Forum versus Attorney General and 3 others, being Supreme Court Petition number 22 of 2017. And determination at the main stage rather than at this interlocutory stage. Similarly, the position taken by the respondent and the third interested party that the failure to join the Senate and the County Assembly of Meru is fatal to the petition, a petition which was strenuously opposed by the petitioner and the first interested party in their respective written submissions, is one best left for the petition stage of this matter, for the reason that the modalities and confines of the interlocutory stage do not lend themselves to an adequate articulation and consideration of matters that go to the heart of whether the petition is merited or not, or if the petition is fatally defective or not. To hold otherwise would be to blur, if not completely eliminate, the distinction between the interlocutory and main stages of the hearing and determination of a petition. The second issue for determination is whether the petitioner approached this court with clean hands. The respondent, in advancing this argument, has at paragraph 40 of its written submissions contended that the petitioner misled this court into granting ex parte interim conservatory orders by not disclosing to this court that the ruling by the Honorable Mr. Justice L. Kassan in Meru High Court Constitutional Petition number E013 of 2024 related to a motion of impeachment by the County Assembly dated 17th July 2024 and not the subject motion of impeachment by the County Assembly dated 31st July 2024 upon which the Senate acted. the question of approaching the court with clean hands is a fundamental one. The issuance of interim conservatory orders ex parte is at the discretion of the court, and should it be subsequently shown to the court that the interim conservatory orders issued by the court ex parte were obtained by the applicant through willful misrepresentation, non-disclosure of material facts, or any other similar conduct, then those orders would be at peril of being discharged, set aside, or vacated, with the further consequence that the applicant would also likely not be in a position to obtain those orders at the conclusion of the hearing and determination of the application that was tainted by the applicant's initial bad faith and conduct. The respondent, in support of its proposition that the petitioner approached this court and subsequently obtained interim relief based on unclean hands, cited Caliph Properties Limited versus Babel, Sharma and another, citation given, which was cited with approval in the High Court succession cause of Mongare versus Kerubo, succession cause number E016 of 2023, where the High Court restated the age-old principle that equitable reliefs cannot be issued in favor of a party who has approached the court with unclean hands, and that party's application for injunctive orders must necessarily fail on that ground alone. The petitioner indeed relied extensively in her depositions on what she saw as the sub judice conduct of both the County Assembly of Meru as well as the Senate with respect to the ruling and orders of the Honorable Mr. Justice L. Kassan. However, and similarly to the position taken by this court earlier on the question of prima facie case, I find that a determination of the merits or otherwise of this issue is best reserved for the main stage, rather due to the nature of the contested facts advanced by the petitioner on one hand versus the respondent on the other. Were it a clear-cut case of unclean hands, which this court could identify and determine at the interlocutory stage, then this court would have no hesitation in doing and determining that question, even at the interlocutory stage. In the present case, the allegation being articulated by the respondent is far more nuanced than the stark instances that were demonstrated in the cases cited by the respondent, and as such, that limb is best reserved for the main stage. Pardon me. All five parties before this court in this matter have submitted extensively on the question of whether the petition would be rendered nugatory if the conservatory orders sought were denied and are not extended to cover the hearing and determination of the petition, the third issue for determination in this ruling. The petitioner, the first interested party, and the second interested party have taken the position that without interim conservatory orders in place at the moment, sorry, let me take that again. The petitioner, the first interested party, and the second interested party have taken the position that without the interim conservatory orders in place at the moment being confirmed and extended to the full hearing and determination of the petition, then the petition would be reduced to an academic exercise. Paragraph 11 of the petitioner's written submissions dated 4th September 2024 succinctly articulates the position of the petitioner and the first and second interested parties on this question. It reads as follows. Paragraph 11 of those written submissions. It is our humble submission that the petition should be heard without disrupting the status quo, as failure to grant conservatory orders would render the petition a mere academic exercise of no effect. Indeed, disallowing the application would have the indirect effect of denying the prayers in the petition, given the irreversible nature of the series of political actions that would follow. We invite the court to take judicial notice of the operations of any government where a change of the governor or president comes with far-reaching ramifications that would not be desired in the pendency of the petition to be determined. Close of quotes. The second interested party added its voice to this question in support of the confirmation of the conservatory orders in force by stating, at paragraph 27 of its written submissions dated 2nd October 2024, that, paragraph 27, the conservatory orders sought are to maintain the status quo until the issues of violation of the petitioner's constitutional rights are heard and determined to finality. Your Lordship, the process of the impeaching the petitioner ought to be interrogated in order for this honorable court to reach a fair and just determination in the circumstances. Unless the conservatory's orders sought are issued, the petition herein shall be rendered otiose. Unsurprisingly, the respondent and the third interested party are of a diametrically opposite view, but for different reasons. I'm just increasing the font. Perhaps I'm growing old. I can barely read. So where was I? Unsurprisingly, the respondent and the third interested party are of a diametrically opposite view, but for different reasons. The third interested party, at paragraphs 12 and 13 of his written submissions dated 30th September 2024, states that in principle, the third respondent was not opposed per se to the grant of the interim orders ex parte, as was done by this court on 21st August 2024, but the third interested party wondered why they subsisted for more than 14 days, contrary to the provisions of Order 40, Rule 4, Sub-Rule 2 of the Civil Procedure Rules. Paragraphs 12 and 13 of the third interested party's written submissions read as follows. Your Lordship, a conservatory order in the nature of an injunction is a judicial remedy sought or issued by a court to preserve a subject matter until the suit/petition is heard and determined. It is, in other words, an order of status quo so that the substratum of the suit/petition is preserved, or so that the same is not rendered an academic exercise. Whereas we have no problem with the jurisdiction of the court and the power to issue such orders, we have a challenge in appreciating why the court would issue an order for more than 14 days. Paragraph 13 then continues, Order 40, Rule 4, Sub-Rule 2 states, an ex parte injunction may be granted only once for not more than 14 days and shall not be extended thereafter except once by consent of the parties or by the order of the court for a period not exceeding 14 days. Close of quotes. While constitutional petitions are undoubtedly civil in nature, the civil procedure rules cannot be solely and directly be applied to petitions such as the present one in all instances. The civil procedure rules, and in this instance, Order 40, Rule 4, Sub-Rule 2, must be read together with the Constitution of Kenya, Protection of Rights and Fundamental Freedoms Practice and Procedure Rules 2013, commonly referred to as the Mutunga Rules, and the latter, being specific to this arena, should take primacy. Rule 23 of the Mutunga Rules, and whose marginal note is conservatory or interim orders, does not make any mention, distinction between interlocutory injunctions in private law on one hand and conservatory orders in public law on the other. Therefore, the principles and procedures for interlocutory injunctions in private law cannot be seamlessly applied to conservatory orders in public law. The respondent, on its part, has taken a different route, albeit to the same destination. The respondent, at paragraphs 29 and 30 of its written submissions, argues that the petition herein cannot be rendered nugatory on account of a failure to confirm and extend the interim orders in place, since the High Court has the requisite power to undo any actions that would have taken place subsequent to a refusal to confirm you.